Welcome to our second episode of the KO Insights podcast. Who owns these AI-generated copyrights?
Users also need to remember that anytime they're interfacing with a software, there's a license attached to that, and there's a licensing agreement. When you're seated there, using ChatGPT, you may not realize it, but there are terms attached to it. Do you own whatever is produced, or is it the platform that claims ownership, not just with intellectual property, but generally anytime you're interfacing with a software platform? And that's something that's always important to remember.
So as a global principle of copyright protection is automatic, and that means that you do not need to register your copyright in order for it to enjoy copyright protection, and in order for you to, let's say, get the law to intervene in the event that somebody infringes on your copyright. However, the incentive for registration of copyright, remember we are speaking about intellectual property and property ownership and proprietorship. And so registration is prima facie evidence of ownership.
Hi, I'm Rosemary Wanjiko, a partner within the firm. Welcome to today's episode of KO Insights podcast. In today's episode, we discuss intellectual property rights, and in particular, copyrights. How do creatives earn? That's a question we seek to answer in this episode. We will delve into the rights and the protections that creatives have under the law, the expected changes within the copyright bill, as well as the role of businesses in the creative space. Stay tuned, learn, enjoy.
Today, we are going to be discussing a very interesting topic which falls under my purview. I'll be your host, and to have this conversation today, I am joined by two very competent persons. They are creatives in this sector, and they're also professionals. I'll let them introduce themselves. We can start with Analo.
Hello, my name is Analo Kanga. I am an intellectual property lawyer. I'm also a jazz musician, and currently I work in the legal department at the Kenya Copyright Board. I'm very happy to be here.
Thank you, Analo. Gentrix.
Hello everyone, my name is Gentrix Wanyama, a technology and intellectual property lawyer, working at Kiptines and Odhiambo Associates in the technology, media, telecommunications, and IP department as a principal associate. And perhaps I can also say I'm a former musician. So happy to be here and happy to have this conversation.
Okay. Thank you so much. Perhaps even before we get to the main topic of the day, I just want us to, unpack for our audience, what do we mean by intellectual property? What forms of intellectual property exist? What are these rights that we're calling intellectual property? Gentrix, you can just elaborate that for us.
Intellectual property is really what is in the name, a creation of the mind or property that one gains by creating it themselves. It's also important to note that IP, as we call it, is recognized under the Constitution as a form of property. So it is a form of property that is intangible and that is created by human beings. There are different classifications to it, of course, copyright being one of them.
Okay. Analo, Gentrix has mentioned one of the classifications of intellectual property. Perhaps you can tell our audience about any other that exists that we could, that they need to be aware of.
Thank you for that. So intellectual property is like a very big umbrella term. So we have copyright, as Gentrix has mentioned, then we have industrial property. So industrial property, we have things such as patents, which protect innovations or inventions. Then we have trademarks, which are like designs, logos, and things like that, which represent a business. So if you're selling a good or a service, we have utility models, details, which are also called petty patents, so a small version of a patent. We have trade secrets, very interesting subtopic there as well. Is there one I've left out?
I think those are the main ones.
Yeah, those are the main ones. So it's usually copyright, industrial property, and then we go into a lot of conversation from there.
Okay. So as we're trying to focus our today's conversation on copyrights, we have seen a lot of developments, especially in our legal jurisdiction today. We have seen a lot of conversations on CMOs, who are these collective management organizations. We've seen a lot of disputes on royalties, which is what we're going to really focus on today. But then, even before we do that, Gentrix, perhaps you can define for us, what is this copyright? How does this right arise? Who enjoys or who even owns these rights?
Thank you for that. And it really is important to dissect. Copyright, as we've said, is a form of intellectual property. Typically, it covers certain groups of creations.
Okay.
So you'd have things like literary works. And when we're talking about literary works, what comes to mind should be things like books. When you write a book, then you say you own the copyright to that book. When you write a poem, you own the copyright to that poem. Another category is musical works. I think the name speaks for itself. That's where the musicians come in. For musical works, of course, you'd have the songs, and in a song there can be different types of copyright as well. You'll find that in one song you'd have the melody to that song. You'd have instrumentalists like Analo laying a layer there, and that's a copyright to itself. Other than musical works, you'd also think of dramatic works. The actors come in here. So when you create a drama, when you create a play, then it is copyrightable. In addition, photographs are also a type of copyright or are protected by copyright. And then you'd also have audiovisual works. These are something like this, actually, a podcast that has both the sound and visual element to it. So there are many groups of works that are protected within copyright, and they differ one from the other, but they are all getting the same protection.
Okay, I love that you're talking about different groups in one setup, which forms some sort of copyright. Now, I'll just choose an example. In a setup like we are right now, in a podcast, there are the people behind the cameras. There's us who are, the orators in this setup. Who owns these copyrights? In any event, I also have my image rights as an individual. If someone takes a photo of me, at the end of it, that's me on that photo. It's me, yeah? So who owns it? Is it the photographer? Is it I, the individual who's been, captured in these images? Or is it even the person who's funded the podcast to be shot?
Or the company.
Or the company. Who owns these rights, Analo?
Yeah, that's a great question. Very pragmatic question as well. So I think that's moves into the conversation of the different kinds of rights. So there are the moral rights and there are economic rights, which are different. So yeah, for you as the orator, as the subject of the photograph or the subject of the podcast, you own your moral rights. And what moral rights means that you own the right to be credited as the orator. You own the right to decide how you want your image to be used. So if you feel like in this podcast we have misrepresented you and your value system and the work that you do, you have the right to say nobody should use that work.
Okay.
And then also you have the right to say that you don't want your face to be used. You want to remain anonymous. You don't want your name anywhere. And so those are more of your individual rights as a human being. And then there's the economic rights, which are mostly contentious, which are now the right to make money, basically. Now that one, it might be the man behind the camera, it might be Gentrix, it might be the company, it might be a third party that has funded us. It depends now on the contractual agreement.
Yeah. And I think that's a very good way of looking at it.
Yeah.
And one thing that I like to say, and I think I've mentioned it just a few moments ago, is that in one work, there's probably so many intellectual property interfaces. Let's take this podcast for one. There's the name, KO Insights Podcast. That's intellectual property.
Yeah.
Funny enough, it's not really copyright. That's something that is more so trademarkable, because then the firm will use that name to put a name to this service, which is the podcast.
Okay.
There is, however, we know that this particular production is a production belonging to the firm, and typically, then the person that is funding a particular production would then be owning the copyright to it, to this audiovisual work. However, it's something that is very, very key is contracts. What is the arrangement between not just ourselves and the firm, who is what I can call the producer of the show, but also what is the contractual arrangement between the firm and the nice gentlemen here who are recording us today. A lot of times you'll find that there's what we call revenue splits between the creator of the work and the people who are shooting it. So it's very dynamic, and it's not always as direct as saying, well, this work belongs to this person, especially when there's a lot of collaboration going into the work. Yeah.
Okay. I love that you've introduced an aspect of revenue streams, because I think this forms part of the basis of what we're just about to get into next. But then even before we talk about revenue streams, you mentioned that copyrights and generally IP are rights or property that is also enshrined in the Constitution. What other laws do we have that perhaps protect copyrights, and what developments are we seeing in these laws? Analo could perhaps respond to that.
Yeah, so I think copyright is recognized internationally for the most part. So there are a lot of treaties, there are a lot of conventions, and obviously we have local legislation. So I think the mother legislation or convention on copyright is the Berne Convention of 1886, which pretty much set a foundation of how copyright is and should be protected. But reeling it back in, we have the TRIPS agreement as well. But here at home in Kenya, we have the Copyright Act of 2001, laws of Kenya, and that is the fundamental subsidiary legislation that governs copyright. Excitingly, and as you have mentioned, we're currently making amendments. So there's a Copyright and Related Rights Amendment Bill 2026 that has just gone through public participation in March of 2026. And so we're trying to amend that bill to catch up to changes in copyright, which for the most part are digital advancements, because in 1886 there was no internet, there was no podcasting. There was no podcasting.
There was no YouTube.
There was no YouTube. On this, I'm sure it was a great time. I wouldn't know, but yeah. So those are some of the things that we're trying to amend currently in Kenya, and obviously because, as you know, Kenya is a leader when it comes to legislation and in the legal field as well. We want to be at par with our global competitors and friends.
Yeah, and Gentrix, Analo has just mentioned that one of the things perhaps the copyright and related rights bill is trying to fix or trying to improve on is on technology. How do we, conform to the new times? Is there any other problem you think that perhaps the bill is trying to address? Do you feel like the bill has addressed it appropriately?
Well, how much time do we have? The bill, as Analo has very eloquently put it, is trying to modernize the copyright regime in the country. Our Copyright Act is from 2001. That's a long time ago. I think Analo was a toddler when it came out.
Maybe.
And so there's the digital aspect. I think for you, Dan, as a tech practitioner, internet service providers are a key feature to this bill. They're being given more obligations in terms of protecting copyright and making sure that anytime there's an infringement on the internet, then they're able to cooperate with the relevant authorities to address that. So that's one very major key provision of the bill. The bill also touches on economic aspects of copyright and how we address them in the country. Something that has been very close to my heart, of course, is the remuneration of artists. There's a saying that we should not be having hungry creators, and that creators should be paid for their work, whether it is from a commercial engagement or even when there is infringement, then they should be rightfully remunerated for that. The bill does something interesting. So right now what we have is that if your rights are infringed, you're able to institute proceedings and you can get damages. The bill has introduced a range for these damages. So listeners or viewers might be familiar with some cases that we have seen in the country. Famously, Nonini has sued quite a number of times and been able to get damages for infringement of his work, which I would think is something good for the industry. But the bill does something interesting, whereas it introduces a range for these damages. And for me, I was having this discussion with Analo earlier. For me, I think that is something that should be treated with caution. I think it's fantastic and wonderful to have a provision saying that if someone's rights are infringed, then they should be compensated. But having a range, especially the range that has been given, I think we're looking at a range of from 200,000 Kenya shillings to around 1 million. For me, that's a bit of a low range. Granted, the bill does say that if you can demonstrate that the value of this copyright is higher, then you can get an exception. But I do think that setting the bar so to speak a bit low would be damaging to an extent. So that is one thing that the bill speaks about, and I think we should keep an eye on. Another thing, and I'll let you jump in and a lot any time, but another thing that the bill touches on is the length of period that copyright is protected in the country. It does bring it up to speed with international standards, I believe. Currently in Kenya, the average length to which copyright can be protected, and I'm going to speak here generally because, as we said, there's so many classifications, but generally copyright would last for the entirety of the creator's or the author's lifetime and 50 years after that. Or what that means is, let's take an example of one of the famous musicians in our country that we've had, Issa. Issa had a very good career, but he died quite young. I think he died, I don't remember the year, 2003. So all the works that Issa created would be protected, of course, during his lifetime, but 50 years also after 2003. So as of 2053, then copyright protection over his work would cease, and that work will come into the public domain. So what the copyright the bill is doing is that it's saying that, okay, yeah, it will last for the duration of the creator's lifetime, but also 70 years after that. So if we were to use the example of Issa, as opposed to his copyright protection expiring in 2053, it will now be 2073. So those are some of the amendments or provisions that the bill is bringing into play. I don't know, Analo, if you want to touch on any others?
Yeah.
Perhaps, Analo, you can also touch on when now we have a bill that's or even the existing laws. Do I have to, undergo some sort of registration for me to enjoy these copyrights? Or what do I need to do? Because as a creative man, I also want to make money from what I am doing. Yeah.
Yeah. So I will answer on registration, and I also have a question for you with regards to what Gentrix has mentioned with the economic bandwidth they've given of that 200,000 to 1 million. I think for a body of work it goes up to 1.5. What your thoughts are on that? But I'll answer first the question you asked me. So for registration, so as a global principle of copyright protection is automatic, and that means that you do not need to register your copyright in order for it to enjoy copyright protection, and in order for you to, let's say, get the law to intervene in the event that somebody infringes on your copyright. However, the incentive for registration of copyright, remember we are speaking about intellectual property and property ownership and proprietorship. And so registration is prima facie evidence of ownership. So if you have a certificate of registration of your copyright, it's the same way you can have a logbook for your car. It's the same way you can have a title deed for a piece of land, or you have a sectional title for your apartment or whatever. So that's prima facie evidence of ownership, and that's important because if somebody infringes on your copyright and you want to take them to court or something, definitely you'll come to the Kenya Copyright Board and you lodge a complaint. You say so and so has stolen from me, and so the question is, how do we know that you own it? Yeah, so that's registration. Then also, if you'd like to use your certificate of registration as collateral for taking loans or any form of financial sort of assistance, you can use that as your logbook, as your title deed. Also, something very interesting that I can mention when it comes to the certificate of registration, I think there's also been the development of I'm forgetting the name, but it's yes, movable property rights,
Security rights.
yes, transaction policy. And so looking at how we can use movable property to allow Kenyans to access credit facilities. And so I think one of the key points to note was that when it comes to movable property, of course, intellectual property is movable because it is, you can't touch it. But yeah, Kenyans, for the most part, use household items when they want to take loans, followed by cars and the rest. So you see, if we can lead in terms of copyright registration, that's another avenue that creatives can use to get loans, to do their projects, to make music, and so on and so forth.
Okay.
Yes, I hope I haven't gone too much on a tangent.
What was your question?
Yeah, my question was, as Gentrix mentioned, so the bill does, and it's public information, the bill does provide a sort of boundary in terms of how much you can get when somebody infringes of your copyright, the lowest being 200,000 Kenya shillings up to 1 million for a single piece of work. If it's a body of work, maybe like it's an album of songs, or like it's a TV show and it has a lot of episodes, that amount of damages rises up to 1.5. There is the exception, of course, that if you can prove that your damages that you have suffered are more than that, the court is willing to offer. But like just as Gentrix has said, they like to follow the law strictly, so it could be a challenge.
You might want to look at this from two perspectives. Yeah, as a creative, it feels like I am being deprived of more that I would have gotten from my work. Okay, as the user, remember, well, this conversation on copyright, not so many people are aware that they actually are infringing on other people's copyrights. You will find, for instance, there is, an influencer, as we like to call them today, who has gotten a brand to sponsor them for whatever content that they have, and then they decide, you know what, there's this hit song yenye imetoka juzi, and I want to use it as my background. Yes, they'll be making some money from the content they're shooting, but they have also used someone's copyright. Now, to them, it might not feel like a very good move for the bill to, say that for this infringement, this is the range for which you're supposed to compensate in case you found culpable. So I think it seems low, but as a step in trying to ensure, people enjoy the use for these copyrights that they own, it's a starting. It's a step forward. It will, at least you will get something, regardless of how small it is. But from a user's perspective, it seems,
I'd like
highly
to push
exploitative.
back. I'd like to push that a bit on that and just follow that train of thinking, which is, of course, right. There are many different interests and perspectives that can come in. And generally, what we have right now is that you can, pray for damages, which there's no particular range. But there's something to be said about, especially corporates or businesses, and the value that they apportion to intellectual properties. What do I mean? Marketing spends tend to be very high. Actually, marketing spends statistically are some of the highest budget points for most businesses. But where is this money going to? Is it reaching the people on whose backs you are building on? So yes, you will pay, I don't know how much to an agency, millions of Kenya shillings, but have you computed how much you need to spend on a song? So that you're not having a situation where, okay, I spent on this particular campaign, I spent, pick a number, 50 million Kenya shillings, and we're getting very good returns out of it. But then I did not compute for music. You want to pay influencers, you want to pay marketers some good money, but then why is it that the marketer should then go and use a song for free? Yeah, so that's just another consideration as well.
Interesting. So now that we're talking money, there's someone who's wondering, I saw my favorite musician record a song, and they released it, and I went and watched it on platform X. In this platform, I don't have a subscription, so I didn't pay for it. In fact, some time back, you'll remember some songs or some clips could be found even on pirated sites. So eventually, how does this musician make money? Let's talk even about local musicians. How do they end up making money? How do they claim this money, Gentrix?
There are many different revenue streams for musicians. I think you have mentioned a couple of them. Of course, right now with the digital wave, we have streaming platforms. We have streaming platforms, and with developments, so people have started realizing a bit of profit and income out of it. A lot of musicians in Kenya do get their money from performances, not really from those digital platforms. One large chunk of revenue streams for musicians is performances. Another one would be royalties. I think you have alluded to it. But royalties are not only coming from the digital streaming platforms. There are many different kinds. In fact, we've just spoken of businesses right now. Businesses are of different kinds, are supposed to pay royalties, and royalties are paid usually to what we call a CMO, a collective management organization, which then is tasked with disbursing those funds to the artists. Whether or not they end up receiving that money is a different conversation for another day. But that is a general revenue stream pathway for most musicians.
There's also something you mentioned on piracy. And yeah, I think piracy is like a global phenomenon and an issue across the board. And when it comes to digital piracy specifically, now that's where we get into tech. So I think like for the bill, it's provided for DRMs, or TPMs. So those are digital rights management systems or technological protection management systems. And basically these are softwares that are able to detect copyrightable material online. And so when somebody uses material that is protected by copyright, it is flagged, and then it's sent to the telecommunications provider or the ISP, the internet service provider, and they are requested to take it down.
Yeah.
And I think that's like an essential other part of the bill. And I think now from then it doesn't go into like who is pirating, but rather what efforts are we putting in as an industry, as an economy, as a country. So I think now those are like more of where we need to collude with other players and like the tech bros to tell us like what are the international standards of DRMs that we can implement in order to protect the copyright.
So I think that explains why you'll come across a video on a social platform, but it has no sound and it says
100%.
Yes.
That's the concept. Yeah.
That's a concept. Another thing would be now not on the piracy front, but on valid digital platforms. So your Instagrams, your Spotify's, they have inbuilt mechanisms. YouTube is another good example. They have inbuilt mechanisms, which typically we call copyright takedowns, whereby if you find that your work has been infringed upon, there is a mechanism that you can follow in issuing a complaint and making sure that that work is then taken down. Then after that, you're either able to collaborate with the person who had infringed on your work and find a way forward, or have it taken down completely. So that's another way to look at it.
Okay. Back to musicians in Kenya and how they're making their money. We have recently seen conversations on our CMOs, the CMOs that we have in Kenya. We have seen what people are calling a shift from a single CMO to multi-CMOs. Perhaps Gentrix, you can unpack this conversation for us. What are these? What is this CMO we're talking about? Which CMOs do we have in Kenya? What are these conflicts we're trying to resolve between the CMOs?
Okay, so CMOs are provided for under the Copyright Act, which basically states that Kekobo is empowered or tasked with the responsibility to license different collective management organizations, which will then help creators or copyright holders to realize benefit from their royalties. Because there are different types of copyrights, then there are also different types of CMOs. And actually what the Act says is that for every type of copyright, and I think our law recognizes around 7, which we stated earlier. So for every type of copyright, there can only be one licensed CMO at a time. Currently, the main ones that we have and are duly licensed by Kekobo are Camp and Pavrisk, which Camp manages royalties or rights on behalf of producers who are holders of copyrights in sound recordings, whereas Pavrisk handles rights on behalf of musicians, songwriters, holders of copyright in melodies and things like that.
Yeah.
So what the situation has been in the past and so far is that we've had a lot of complaints coming from the market, coming from the industry, where musicians are saying, hey guys, we are doing our best here. We are producing music, doing our best to put out work out there, and we need to earn a living. However, after a year's work, the money that I'm receiving is negligible. It's not making sense. That has been a major outcry for a lot of creatives who are saying that we do know that there are these CMOs that are licensed and they're supposed to be collecting revenues on our behalf, but I'm not seeing on my end that money coming to my pocket. That has been the main concern. Another concern has been with transparency. How do they calculate the money? So first of all, how much money do they actually receive? And secondly, how do they then manage this money? And lastly, how do they calculate the money that comes to the musicians or creators' pocket? A concern has been that majority of the money collected is being used in administrative fees within the CMOs, and then only a small percentage is then being disbursed. So that has been, it's historical. It's happened for a long time, not just with the CMOs that are currently licensed, but even with past office holders. We've seen that concern.
So, other than the CMOs now, do you think artists, copyright holders, have been fairly compensated generally, even by streaming platforms, for instance?
I'd like to hear Annal's take on this.
As a creative.
As a musician, myself, I think that's like a more global conversation. And I think I can say, without fear of being abducted, that the answer is a resounding no. And it's for several reasons. I mean, there's one thing Gentrix mentioned at the beginning, which is the value we attach to our art.
Yeah.
And so not only is it our culture as Kenyans, but globally, where people don't really feel like they need to pay for music, in the sense, like they just feel like they should enjoy their favorite songs. What I will say, the reason as to why musicians are not fairly compensated, especially through digital streaming platforms and royalty collection, is actually because there is so much money in the industry, such that there are so many people who come in and want to partake of that pie. So you'll find, like, for DSPs, there's the music distributors, and then you have the DSPs. So you have the artist, you make your song, and then now you need to get it to Spotify, but you can't just give it to Spotify directly in theory. So you have the music distributors. Now these are third-party companies that now sign licensing agreements with the DSPs, and then they distribute your song. So some of the incentives they'll give you is, like, if you pay an annual fee of like 5,000 Kenya shillings, we'll make sure that your music goes to Spotify, Apple Music, YouTube Music, and the rest. And then now comes to how much do you pay for streaming. And so one stream is like 0.001 shilling, or it's like just it's very cheap. So like maybe like a thousand streams or 100,000 streams can give you like 10, 15, $20. And that's also because, like I've mentioned, there are so many people eating from the pie, and then also the mindset of how much do we value our music.
Okay, that's interesting to note. Perhaps I just want to shift this to something very different. We've talked about money for quite some time now. Let's talk about the new technology, what we have right now. AI is becoming a very diverse tool, an everyday tool for some people today. There are people who are leveraging an AI, and perhaps just a disclaimer to our audience, when you talk AI, most people will just jump to ChatGPT. We have so many AI platforms. We have so many AI models that do a diverse number of things. So AI in copyright. Okay. When I give a prompt to my AI to generate some form of content which ends up being a copyright, who owns it? Do I own it? Does the developer of this AI tool own it? Who owns these AI generated copyrights? Gentrix.
Good question. And it's come up several times across multiple jurisdictions. In many court cases already, we're seeing litigation on that. And even here in Kenya, the Copyright Tribunal last year, 2025, had a case whereby they addressed it slightly, not very comprehensively, but at least we're seeing a bit of movement. Now, there's no direct answer that we can give to that, because number one, it's still a developing area of the law, and secondly, when it comes to creation, then context is very important. Let's take the scenario that you have given us. There's someone seated at a computer giving it a prompt, giving a particular platform a prompt, and then it generates some music. Of course, this platform was created by a developer somewhere, or by a company somewhere. So the first thing that we need to realize is that on a legal perspective, intellectual property, as we said at the beginning, is recognized as to a person. So the person who only a person right now, only a natural person is able to own a piece of intellectual property. And I'm speaking from a general perspective, looking at what the laws are currently. We do not know what will happen. Maybe 5 years from now, we might be having a different conversation. So that's just at a general point of view. Users also need to remember that anytime they're interfacing with a software, there's a license attached to that, and there's a licensing agreement. When you're seated there, using ChatGPT, you may not realize it, but there are terms attached to it. Do you own whatever is produced, or is it the platform that claims ownership, not just with intellectual property, but generally anytime you're interfacing with a software platform? And that's something that's always important to remember. Now, getting into the crux of the question of what you have asked, is it possible to have copyright in a piece of work that I have generated from an AI platform? I would say it's possible. However, it goes down into the definition of what copyright is and what it means to have copyrightable work. So remember that, and this is something that the Copyright Tribunal said in its decision last year. How they're looking at it is that for a work to be copyrightable, it has to be original. What does it mean for a work to be original? Under copyright laws, originality is dependent on the amount of effort that you put into a particular work to make it original. So, for example, for a song, you cannot just come and copy someone's melody and put your own, words to it. It has to change and transform into a new piece of work. So, what the Copyright Tribunal said in its decision is that it will really boil down into the strength of the prompt and how comprehensive it is, and then finally the resultant work, how new it is. If you compare that to different jurisdictions, we've seen cases out of the US and UK. They're taking different approaches. The US is saying work is not copyrightable if it's being generated from an AI system. What will happen is that there'll be a distinguishing factor between, you have a whole copy, you have a whole body of work, maybe it's a piece of writing. They'll distinguish what was generated by the AI and where did you maybe input your own work into it. So a part of it will be copyrightable and part of it will be excluded from copyrightability. The UK seems to be taking the approach that the Kenya's Copyright Tribunal took, whereby they're saying, if you expend a certain amount of effort, then maybe it might be copyrightable. But it's still an area of law that should be monitored, and musicians should look into how they can protect their work.
Okay, thank you for that response. And as we continue, just want to, just as a follow-up to what Gentrix was talking about, Analo, we are continually trying to develop our technology. Even what we call AI, we are continually trying to improve it. And one of the ways that we do this is by machine training. So do you think that AI training can infringe on copyright?
Well, as Gentrix was speaking, there's something that kept ringing in my mind, and is ethics, and the ethics of using artificial intelligence to make content or make creative copyrightable pieces of work. And so when you use copyrightable material to large language models. I think that's your LLMs. The question is, one, are you protecting the author or the author who is the original owner? So the original author, are you putting them into context? Number two, what are the remuneration kind of agreements? Because I think it's insincere to say that is not going to happen or will not happen or does not continue to happen. I think especially like in the US, there's already jurisprudence on AI companies and software development companies signing agreements with libraries or institutions that carry copyright. So this could be like your libraries, like for books. It could be like people who have songs. It can be your DSPs. It can be whoever. It can be your social media platforms or anyone who is a controller of copyrightable material to use that work in a licensing agreement. So I would say, in as much as it's a gray area, I think a more forward way to look at it is like, what are the contents of the licensing or assignment agreements we're going to make? Because technology is going to continue moving forward. AI is going to infiltrate the entertainment or music industry even more, but like, what are the ethics of it? Are we protecting the authors? Are they getting their royalties? Are they getting remunerated? What is the length of that licensing agreement to train those AI models? What are the moral rights that we're protecting? Are we going to use somebody's copyrightable material to maybe work on an AI model or software that goes against their personal values? Do we want to have that conversation, or is it all about the money? Yeah, so I think the ethics of AI use in copyright is like a very big factor. Are we even ethical? What are ethics?
Okay. I just want to wrap up this conversation because I realize we might continue speaking for a while. But as we wrap up, I want you to think about this one question, which you can respond to as we close. What is the future of copyright in Kenya? And before you give me a response to that question, I just want to shoot some random fire questions. These are questions I got from one of the people I was talking to as we were preparing for this podcast. One, what is the biggest misconception about copyright? Gentrix?
That copyright is trademarks. I hear a lot of people saying, "Oh, I need to trademark my song." So just not knowing exactly what it is, I think.
Okay. We talked about the duration for copyright.
Oh, I have one more.
Sorry.
Misconception. Copyright does not protect ideas. So you can't have. So yes, ideas are golden. I think there's a saying like that, or ideas are gold. So it doesn't matter if you have like this elaborate script in your mind, or you have a song in your mind. You cannot copyright that. You have to put it in a tangible format, whether it's writing it down, whether it's putting that song in an MP3, whether it's publishing that book, for you to gain copyright protection. Yeah.
Okay. We talked about CMOs, and Gentrix told us we currently have 2 licensed CMOs. Do you think we should have more or less?
I think we should have more. And my reason is, if you look at the people they're projecting, who are the producers, the artists, and everyone, if we have more CMOs, it is a more competitive environment. I think in other jurisdictions, they have maybe 2, 3, 4 CMOs. And so each CMO presents to the client, who is the artist, the creative, these are the returns I'm going to give you from the royalty collection. Here we do 68%, here we do 69%. In terms of remitting royalties to you. So that will enhance the competitiveness of ensuring that artists are remunerated equitably. That's my opinion.
Gentrix?
I actually agree, but not with the same application. I think that we need to have more diverse CMOs doing different things. So in terms of specialization, because our current regime lumps together so many different rights. And remember, here we're only talking about music. We haven't thought about all the other types of copyrights that are there, which still actually incidentally affect the musician. So a musician will have when they make a song, they'll have the video, for example. Who is watching out for that? Who is making sure that the dancer gets some royalties for being a performer in that particular video? So when you look at jurisdictions that do very well in terms of making sure that performers or artists realize good returns from their royalties. I was looking at a jurisdiction like France, for example. They have specialized CMOs, and of course, there are other considerations into this. Our economy is, comparatively a bit smaller, but yeah, I think more CMOs could do a lot for the economy in terms of making sure that every revenue stream is compensated for.
Okay. Last question.
What do you think on that question?
Well, I would say I would love to see a situation where we have more than 2 CMOs. And my reasoning is purely based on competition. If you look at the markets in Kenya currently, whatever market it is, whether it's some shoe vendor out there who's selling shoes or someone who's selling bottles, if they are the only person in this market, then they tend to have bigger market control and they end up dictating the terms. If you have multiple people in this business, then you're sort of creating competition in the market, which then ensures there is better returns for the people in this market. So I would want a situation where we have multiple CMOs. 2, I'm also looking at a scenario where we don't have any CMO, or we have just one CMO, and we leave our artists, our creatives to the beg and call of this one individual. It's even worse if there is no CMO that exists, because then it's difficult and very hard for each artist in their own individual capacity to go on claiming for royalty payments from each and every person they assume to be using their copyright. So yeah, I agree, we should have more for sure. But just as much as we are having these multiple CMOs, thinking of it from the consumer side, then the CMOs need to have some sort of regulation and balance in between them, so that you don't come claiming for royalty payment for me, and tomorrow Gentrix is claiming again, the other day Anhalo is claiming. There needs to be some sort of MOU and uniformity. So to my last question, what is one reform in copyright that you would implement immediately today?
One reform in copyright I would implement today. Well, I definitely have a bias towards the bill. So I think implementation of the bill and fundamentally the increase in the work that the Copyright Tribunal does, or ideally the Copyright Disputes Tribunal. So like the enforcement of orders given or rulings given by the tribunal, so that we're able to even go further into stopping infringers, digital pirates, we're able to take them to court, they're able to pay damages and so on and so forth, so that it acts as a deterrent for people who are infringing or pirating copyrightable work.
Okay, Gentrix, one instant reform.
I think I would make it easier for artists and creatives to have collective bargaining. Because I think we only think of CMOs from point of view of royalty collection, but there is a lot more need. Royalty is just one stream, but there's more need. Artists need to have access to healthcare. Artists and creators need to have things like what Anna was talking about, access to financing. They need to be able to bargain for better rates when they're performing or appearing in studio. So yeah, I would make it easier for them to have collective bargaining.
Okay. Now to the question I said would be the last question. What is the future of copyright in Kenya? A very short answer as we wrap up.
Copyright has a bright future in Kenya. Our economy is around 80% youth, and youth tend to be very big on copyright.
Yeah.
yeah, we have a bright future for copyright because we are moving in the right direction, and copyright will become part of the backbone of this economy and society if we nurture it in the right way.
Yeah, so I think the future of copyright is dynamic. And it's dynamic because we are going to have, or we're going to need a lot of industry players from different industries coming in order to develop copyright. Tech is a very big part of developing copyright. Almost everything right now is digital. Like Gentrix mentioned, the GDP of the country and basically how much money copyright generates, and the creative industries in general, the orange economy, as we like to call it, is definitely going to balloon and skyrocket, not just for Kenya, but in Africa in general. So the future of copyright is dynamic in terms of how we think about it and how we apply it.
That's it for today. We've come to the end of today's podcast. And as my panelists have rightly put it, Msani Alipwe, we have learned and have seen that copyright sits at an intersection of key attributes in the economy today: creativity, technology, and even with AI. And if you would like to have this conversation any further with us, we are happy and delighted to sit and talk and see how we can help you protect your copyright, or how we can help you ensure that you're not in infringement of anyone's copyright. You can reach out to us on the email below. You can also check out our website for more interesting content and conversation. That's it for today. See you on the next episode.